Um, I'm Leslie Hughes. I want to tell you I'm very happy to welcome and introduce Shira Perlmutter to our conference. Shira is the Register of Copyrights and Director of the U.S. Copyright Office. She was appointed to the position effective October 25th, 2020. Shira leads a workforce of approximately 450 employees, advises Congress on copyright policy, and directs the administration on important provisions of the U.S. Copyright Act, Title 17 of the United States Code. Prior to her appointment as Registrar, Shira served as Chief Policy Officer and Director for International Affairs at the United States Patent and Trademark Office, USPTO, where she was a policy advisor to the Undersecretary of Commerce for Intellectual Property and oversaw the USPTO's domestic and international IP policy activities, legislative engagement through the Office of Governmental Affairs, education and training through the Global Intellectual Property Academy, global advocacy through the IP Attaché Program, and economic analysis through the Office of the Chief Economist. Before joining USPTO, Shira was Executive Vice President for Global Legal Policy at the International Federation of the Phonographic Industry. She held the position of Vice President and Associate General Counsel for Intellectual Property Policy at Time Warner, and prior to that, worked at the World Intellectual Property Organization in Geneva as a consultant on copyright and electronic commerce. In 1995, she was appointed as the first Associate Registrar for Policy and International Affairs at the U.S. Copyright Office. She was copyright consultant to the Clinton Administration Advisory Council on the National Information Infrastructure in 1994 and 95. From 1990 through 95, Shira was a law professor at the Catholic University of America, teaching copyright law and trademark and unfair competition law and international intellectual property law. She received an AB from Harvard University and a JD from the University of Pennsylvania. I have to say, I am truly honored to have Shira join us today to discuss copyright in today's ever-changing environment. So welcome, Shira, and I'll turn it over to you.
Thank you, Leslie, for that kind and generous introduction, and good morning, everyone. I'd like to begin this morning by outlining the Copyright Office's new strategic plan and describing some of the exciting projects we're working on to further the goals outlined in that plan. And then, because I know that artificial intelligence is a topic on everyone's mind these days, I'll talk a bit about the current copyright issues at stake. And I'm joined by Rob Kasanek, who's the head of our Office of Registration Policy and Practice, and the two of us will be happy to answer questions at the end. So in January, the Copyright Office released a new strategic plan, and it sets out 4 high-level overarching goals. The first is what we're calling copyright for all, and I'll talk about that more. The second is continuous development. The third is providing impartial expertise on copyright issues. And the fourth is enhancing our use of data. And just to start with number 1, it's not a coincidence that the first goal we set out is copyright for all. The way we're defining this is an attempt to make the U.S. copyright system as understandable and as accessible as possible to as many members of the public as possible, whether they are individuals or small businesses or larger entities and professionals. And it's especially important in this day and age where everyone using the internet is both a creator and a consumer of copyrighted works. Now, outreach and education have always been a major focus of the Copyright Office, but now we're really expanding and intensifying our work in this area. And that means a number of things. It means making our services easier for people to use without expertise. And it means publicizing some of the new programs and structures that Congress has created. But one very important aspect of all of this is to raise awareness of copyright in the general population and broaden participation in the system. And so to that end, we recently released a study on women in the copyright system. And this involved analyzing some 20 million copyright registrations over a 42-year period starting in 1978. And the study showed that women authors are underrepresented in their use of the copyright registration system. But at the same time, it showed some encouraging trends. The gap between male and female authors in registering their works is getting smaller in every category of work. And most impressively, in the area of registrations for non-dramatic literary works, women authors now represent 50%. So definitely improvements are happening, but the percentages are still considerably lower in other areas, in particular in areas related to science and technology, as may not be an entire surprise. It's also clear that there's still work to be done to reach gender parity in these other areas. And our research also showed that in almost every category of works, women make up a smaller share of copyright registrants than they do of participants in corresponding occupations. So for example, artists for works of visual art, or musicians for works for musical works. So our first chief economist that we just hired this year, Brent Lutz, will be doing research to identify other potentially underrepresented groups in the copyright system so that we can develop additional outreach targeted specifically to those groups. In addition, I recently joined the Department of Commerce's Council for Inclusive Innovation, sometimes called CI Squared, as one of the co-vice chairs. And the purpose of this group is to collaborate with colleagues from industry and academia, as well as government, to develop new ways to broaden participation in the innovative and creative sector of the economy. So I'm excited about that work as well. Another huge step toward copyright for all has to do with access to justice. So about 2 years, almost 2 years ago now, Congress passed what's known as the CASE Act, which required the Copyright Office to set up a new small claims tribunal for copyright cases. And in June, we launched the new Copyright Claims Board, or CCB, which offers a faster and less expensive alternative to federal court for copyright claims asking for up to $30,000 in damages. And this is a very exciting moment because this tribunal will make justice available to people who in the past couldn't afford to litigate their copyright claims. And in less than a year and a half, we were able to set up the CCB's regulatory framework, complete all hiring for the board and its staff, and set up an electronic case filing and management system, as well as virtual hearing facilities and office space. We've also produced extensive materials about the CCB, which are available online, and that includes a dedicated website, ccb.gov, a user handbook, educational videos, and FAQs. So it's been really quite a project using our expertise in every part of the office. And to date, since the CCB opened its doors in June, more than 200 claims have been filed. And they involve a mix of issues and of types of works. And the CCB is now moving to process them. This is ongoing, the work is ongoing. Respondents are able to opt out once they've been served with a claim, and they have 60 days from the service to make that decision, whether to opt out or to respond. So it's too early yet to know how heavy the caseload will be because we haven't reached that period of 60 days from service for any of the claims. So meanwhile, we are very busy because in addition to the CCB itself processing the claims, the Copyright Office is very actively publicizing the existence of the CCB and how it is operating. We want to make sure now that we've built it that people will actually come and use it. On our second goal of continuous development, we've been very focused to date on our current modernization initiative. And the major news there is that on August 1st, our new electronic recordation system opened up for use by all members of the public. And what's so exciting about this is that it moves us from a very antiquated paper-based system so that we will be fully online going forward. And this is the first publicly available component of our planned enterprise copyright system, or ECS, which will update and link all of the office's services. And I'm excited to report that we've seen a substantial increase in the number of users of the electronic recordation system since it was open to the public. And processing times are way down. They are measured now in weeks rather than months. So I would say overall, the online system is a big improvement for users, and I hope we will continue to see an uptick in its use because it is cheaper, it is faster, and it is more accurate. We've also continued to improve our pilot of a new copyright public record system, or CPRS. And the goal here is to replace our existing public catalog in the near future in a way that makes it also faster and easier to use. And then finally, the biggest component of ECS is the new and improved online registration system. Now, this is a complex project, but we're working on development and in fact, picking up the pace. And that will include enabling the upload of very large files like motion pictures and large numbers of files like photographs and newspapers for group registrations. And when this is finished, it will really represent a major improvement over the current ecosystem that people may be familiar with. It will be much more accessible. It will be much more user-friendly. But the reason we're talking about continuous development is that even when the current modernization initiative is completed and ECS is available to everyone in full, we want to regularly review and update all of our IT so that we don't have to keep starting from scratch over and over again when it becomes out of date. And skipping to our fourth goal in the strategic plan, enhancing our use of data, this is another way that we will increase access to the copyright system. In June, we published the bulk data that underlay the Women in the Copyright System report. And that was a first for the office, but we're not going to stop here. We do plan to continue to make data available in useful formats. And the plan is that researchers will then be able to use those resources to increase knowledge about and access to the copyright system. And our new chief economist, as I mentioned, Brent Lutz, is also developing a comprehensive research agenda to support evidence-based policymaking and operational decisions. And that will include beginning preparatory work for our next fee study. So let me turn to our third goal of impartial expertise. Now, in this area, copyright, well, Congress is continuing to keep us very busy responding to numerous requests, and I'm going to mention three. One has to do with the use of technology to address online infringement. The second has to do with proposals for a new deferred examination system. And the third has to do with non-fungible tokens, or NFTs. Last year, Senators Leahy and Tillis asked the Copyright Office to convene a working group to achieve the identification and implementation of technical measures used by copyright owners to identify or protect copyrighted works. So we initiated a process of consulting with stakeholders and collecting public comments. And in the first week of October, we held a concluding plenary session. There's been a lot of interest and very active participation from a wide range of stakeholders. And one thing I can say is that it's clear already that context is critical when you're looking at technical measures, and it is impossible to develop one-size-fits-all approaches. So stay tuned on this because we will be outlining our findings in a report to Congress before the end of the year. In addition, also at the request of Senators Leahy and Tillis, we've been looking at standard technical measures, or STMs, as defined in the DMCA in a separate initiative, a separate project from the consultation on voluntary measures. And back in 2020, we had issued a report on Section 512, and in that report noted that stakeholders had never agreed on the adoption of any such STMs. And that's important because the DMCA establishes obligations for ISPs to accommodate and not interfere with STMs. But as a practical matter, it's difficult to develop technologies that meet the current statutory definition, in particular because it requires a consultative multi-industry process. Now, earlier this year, in response to the senator's request, we sought comments on the interpretation of that section of the law and the advisability of any potential changes. And we're now reviewing those comments, and we will report on them to Congress also by the end of the year. And in March, Senator Tillis introduced what's known as the SMART Copyright Act, which would establish a rulemaking process in the Copyright Office to provide for the designation of STMs. Now, clarifying the statutory definition may make sense and be helpful, but I just will note that we have some concerns about the office's ability to accomplish this through a rulemaking that would require considerable technological expertise and substantial resources. So again, stay tuned. A lot may be happening in the next few months on technological measures. On deferred examination, we recently completed a study that looked at the feasibility and costs and benefits of creating a new option for copyright registration where examination of the claim could be deferred until requested by the applicant. So the idea was that delaying full examination would be a way to reduce costs, reduce fees, while still allowing the applicant to obtain an effective date of registration upon submission of the application. Now, when we conducted the study and looked more closely at how deferred examination would work in practice, we found that it would create some problems, including issues related to the integrity of the public record, and that it likely also would not actually reduce our costs. But we do want to address the concerns that were identified in other ways. So we're looking at alternative approaches to registration that could reduce the burden on applicants and make registration more accessible to everyone. Now, the things that we're considering won't require congressional action in our view, but they will depend on developing technical capabilities that we would like to achieve in the new ECS system. Now, what are some of those new approaches? Well, we will be studying the introduction of a dynamic fee structure and subscription pricing. And once we figure out what options are possible in the new technological environment of the ECS, we will start a regulatory process to obtain public comment. We also want to create technological opportunities for APIs to enable hardware, software, and third-party organizations to achieve integration with the ECS system. And we're looking at how to increase the maximum limit on the number of photographs that may be submitted in a single group application by achieving enhanced upload capabilities and more efficient examination capabilities in the ECS system. And then finally, in the coming year, we intend to initiate a notice of proposed rulemaking on a new group registration option for two-dimensional artwork, also to be implemented in the ECS system. And then finally, the third issue I'll mention is non-fungible tokens or NFTs. And here, at Congress's request, we will shortly be initiating a joint study with the Patent and Trademark Office on the IP implications of NFTs. So again, stay tuned. We will be publishing a Federal Register notice shortly, soliciting public participation and input. So let me now turn to AI. We, of course, continue to examine all of the issues, the copyright issues that arise from emerging technologies such as artificial intelligence.